briefing. Let's go ahead and proceed.
All right, Miriam, you want to put the first slide up, please?
Go ahead. Okay, go ahead and make your argument. Mr. Roberts, are you there?
We'll accept the default, Your Honor.
Yeah. Mr. Roberts, are you there? Mr. Friedman, are you there?
I'm right here. Can you hear me, Your Honor?
Yeah, I can't hear Mr. Roberts, and I can't see him either. Let me see. Is he here?
Judge, let me get him back on. Give me one moment. Sorry.
Okay.
Okay, I apologize. I got booted out of the meeting, but I'm back. May I begin now?
You may.
All right. Judge, in her first cause of action in her fifth amended petition, Gail is suing Cliff for the breach of fiduciary duties. You can see some of the allegations that we have on our first slide. As a part of that cause of action, Gail is suing Cliff for a breach of fiduciary duties based upon at least three formal relationships. First, the formal relationship of Cliff and Gail being co-shareholders of a closely held corporation. Second, the formal relationship of Cliff being an officer and a director of the company. And third, the formal relationship of Cliff being Gail's ex-husband. The indisputable case law is, however, that none of these formal relationships give rise to fiduciary duties. As a matter of law, a co-shareholder in a closely held corporation does not owe a fiduciary duty to his other co-shareholders. Therefore, Cliff never owed Gail a fiduciary duty just because they are co-shareholders of the company, which is a closely held corporation. Second, as a matter of law, the fiduciary duties of a corporate officer and director run only to the corporation, not to the individual shareholders. Therefore, Cliff never owed Gail a fiduciary duty just because he was an officer and director of the company. Third, as a matter of law, the formal fiduciary relationship between spouses terminates when their divorce is contested and they each retain their own independent counsel. Therefore, Cliff stopped owing Gail a formal fiduciary duty as her husband when she filed suit to divorce him and hired her own independent counsel to represent her against him. The case law on these issues is voluminous. Those cases are cited in our motion and our reply, and you will see that in the reply, we set out multiple quotes on these issues of law. Gail's response raises two separate objections. First, Gail makes the point of repeating that there may well be informal fiduciary relationships between Cliff and Gail, and that precludes the entry of the requested summary judgment. That is nothing but background noise, the legal equivalent of Muzak. The motion does not seek summary judgment on any informal fiduciary relationship. Rather, the motion requests partial summary judgment based on the absence of the three different formal fiduciary relationships that I mentioned. Because the existence or non-existence of formal fiduciary relationships are a question of law, it is this court and not a trier of fact that must make this determination. Second, Gale argues that Family Code Section 9.001B creates a formal fiduciary relationship owed by Cliff to Gale. Now you can see that statute right up on the screen, and it says the subsequent actual receipt by the non-owning party of property awarded to the owner in a decree of divorce or annulment creates a fiduciary obligation in favor of the owner and imposes a constructive trust on the property for the benefit of the owner. In her response, Gale argues that because the divorce decree has provisions requiring that Cliff and Gale receive shareholder distributions in equal portions pending the sale of the company, that created a formal fiduciary obligation owed by Cliff to Gale. This argument misapplies that provision. In order for Section 9.011B to apply, property must be owned by one spouse and awarded to the other spouse in their final divorce decree. The obligation of the owning spouse to turn over the property to the other spouse is a formal fiduciary obligation. We cite cases in our reply on that point. In the Piculin case, the wife had a fiduciary obligation to turn over to her husband a portion of her retirement checks, property she owned. And because she did not immediately forward them to her, she breached her fiduciary duty. In the Ishii case, the husband, as an assignee, property he owned, had a fiduciary duty to remit to the wife her percentage of the amount of income, loss, or distribution he actually received from the businesses identified in the divorce decree. Here, however, under the divorce decree, the provision cited by Gale in her response is not what is going on. The provision involves money paid by the company to Cliff and Gale as shareholder distributions. Let's read that. Further, any distributions made to Cliff or to Gale during the pendency of the sale shall be made in equal portions. This does not concern property owned by Cliff that is awarded to Gale and which Cliff must turn over to Gale. Therefore, this section of the Family Code does not apply to create a formal obligation owed by Cliff to Gale. If, Your Honor, by chance, the divorce decree actually does create other formal fiduciary duties, our motion doesn't cover them. They are still there. So the existence of new formal fiduciary relationships created by the divorce decree, which we don't think exists, but if they do not provide a reason to deny our motion for the formal fiduciary duties that are a part of the motion. In conclusion, summary judgment is meant to whittle away and do away with improper claims. And that is what this motion does. The motion applies the existing Texas law to the absence of formal fiduciary duties, fiduciary relationships, that as a matter of law, a co-shareholder in a closely held corporation does not owe a fiduciary duty to the other co-shareholders. That as a matter of law, the fiduciary duties of a corporate officer and director run only to the corporation and not to the other individual shareholders. And finally, that as a matter of law, the formal fiduciary relationship between spouses terminates when their divorce is contested and they each retain their own independent counsel. Therefore, the motion should be granted for the partial summary judgment requested. Thank you.
Response?
Your Honor, there's much in this that I can agree with Seymour. I believe that there is, as between shareholders in a typical situation, there are no fiduciary duties. I believe that he's stated correctly the marriage issue on fiduciary duties, and he stated that correctly the fiduciary duties with respect to officers of a corporation. The problem that we have with what he has said is that the order, unless very carefully crafted, will end up causing a lot more problems for us legally than, and Your Honor, than it should. The claim, if you look at paragraph 54 of the actual Fifth Amendment, you'll see that she has alleged that there are fiduciary duties that arose during the marriage. And as a result of those breaches, there are damages that we are entitled to, as well as punitive damages that we are entitled to. So we don't contest the fact that at the hiring of a lawyer and at the marriage, when the marriage ends, the fiduciary duty ends, but there are claims that the marriage itself created fiduciary duties that gave rise, that are breached, and that's what the allegation is. If we are to limit it simply to when the lawyers were hired and when the divorce decree occurred, then that's fine. I mean, I think that is the law, but that's not what his order said. And that's why we were concerned about that. That's why we wanted a hearing. The second issue is that as to the divorce decree itself, I think he's got it backwards. That decree created a series of duties that are fiduciary duties in and of themselves. I think Seymour Roberts basically conceded that that was the allegation that we have made. And as a result of that, those breaches of fiduciary duty survived this summary judgment. Those are informal relationships. The family law argument that Mr. Roberts has argued, I think, is not applicable here, because the way in which the petition, the Fifth Amendment petition is framed, it goes something like this. Both parties, particularly Cliff, has a fiduciary duty to her, to Gail, because he has to cause the money to go equally to himself and to her. He becomes the agent. She is the principal. It is bedrock law in Texas, and Your Honor has tried cases. I think I have tried cases before you where fiduciary duties as between an agent and the principal exist. And those are the kinds of fiduciary duties that exist here. What's more, those parties who were on the board of directors during the course of these breaches agreed to and therefore joined the conspiracy to breach the fiduciary duties to Gail. And as
objection, Your Honor, this is something that is not in his pleading at all. He didn't talk about board of directors. He didn't talk about conspiracy. He didn't talk about any formal fiduciary duty except one.
Mr. Roberts doesn't get to talk while I'm talking, as I recollect.
But I get to object.
Mr. Roberts, let him finish.
Okay.
So as a result of that, we claim the formal breaches of fiduciary duty, if limited to just that and the articulation of them by Mr. Roberts, we don't have objection to a summary judgment being issued on those matters as he has argued it. But the order has to be extraordinarily well crafted in order to avoid impinging upon the likely claims that we believe we have and will go to trial on. So
why don't we do this then, Mr. Lynn? Why don't you draft this order, since you're the one most concerned about the exact phrasing of it, and you share it with Mr. Roberts and Mr. Friedman. And if there's an issue with the form of the order, and then let's sign back up on this call tomorrow at 9. I don't want this to be delayed. If the form of the order can be agreed to, then go ahead and submit it, and you guys don't need to sign back on.
I will make one comment in response to Mr. Lynn. There
Sure.
is no evidence that either Mr. Fisher or the Board of Directors has had any participation in not distributing equally funds to Mrs. Fisher and Mr. Fisher. To the contrary, all the evidence and the evidence in Mrs. Fisher's possession, because she gets the financials every month, demonstrates that both parties have had equal distributions at all times for the last 20 years.
Okay, that is a closing argument. That is not a summary judgment argument.
Well, that was your closing argument.
All right, guys, go ahead and get me an order on this, and we'll go from there. Anything else,
Thank you.
guys?
Yes, Your Honor, if you, we have one more issue.
What's that?
There are depositions coming up of Gail in this matter.
Mhm.
We are filing a motion for protection today to limit the amount of deposition time. And perhaps you could hear that tomorrow if at all possible. I realize
I thought I already heard this.
You
You did hear, Judge, you did hear it. You awarded us 12 hours. If
Yeah.
Mr. Lynn wants to file an appeal, he wants to file an interlocutory appeal, a mandamus, he can do all that, but he can't come back in and reshuffle the deck. He can't come back in and re-argue something that's already been ordered by this court.
Your Honor, the actual order, I believe, is maybe we're asking for reconsideration of it. But what we would like to do is have you hear this, because they are taking, 12 hours for basically a very few number of pages of errata sheets. Your Honor, I'm not aware of anybody in the court system here.
Your Honor, there's no motion before the court. There's
Motion
no
will be
pleading.
filed. Now, wait a second, Larry. I was asked, is there anything?
When is the deposition set?
The 20th and the 21st.
Oh, I'm going to get you a motion today.
Okay,
Why don't
I
we do
mean,
this? If you want this heard, Mr. Lynn, and I just vaguely remember we talked about this before, maybe you brought this up, and if it's just about the errata sheet and I said 6 hours apiece, that doesn't, maybe that, I don't know, but that does seem like a long time to just deal with the errata sheet, because she's already been deposed once,
there
right?
was
Already been
107
deposed.
wait, there was 175 changes on the errata sheet.
But she shortened down the errata sheet after the complaints were made. So there is a much smaller errata sheet. They are basically asking.
I'm sorry, there's 225 changes because she changed the 175 again. So look, I have never seen.
I'm not going to make any
175
rulings
changes.
on this. All I was going to say is, if you can file this today, I'm just trying to figure out scheduling. If you can file this today, Mr. Land, the motion to reconsider, I'll hear it on Friday. And Rhonda, if you're still here, I'm not sure. You can hear, I can hear it on Friday. I don't think it's fair to Mr. Friedman to have it heard tomorrow, just because he's not gonna have a chance to respond. But if you can
Thank
file
you.
it today, I'll hear it on Friday.
Thank you.
Yes, sir.
10 o'clock, 10:30?
Let's say 10 o'clock, but if it's not filed today, then I'm not hearing it on Friday.
Well, Judge, can we have it filed before close of business today? Mr.
Yes.
Lynn has a habit of filing things in the evening, and then I can't get to them.
Mr. Roberts, that's just so much nonsense. I received a response from you and I filed it by I think it was 9 o'clock. I filed a response by 7 o'clock, which to me seems like I am moving very quickly. So,
Okay, well, he's a night
Mr.
owl.
Lynn, you need, I'm not commenting on whether you've done that or not. I don't honestly know. But for this particular motion, because it's time sensitive, you need to file it by 5 o'clock today.
we will.
Thank you. Thank you. Thank you.
All right,
Thank you,
guys, and this
everybody.
was on YouTube, and just so you know, so if there, I don't know that this was on the record, but if you need to kind of cite back to it, this was on YouTube. So,
Thank you.
all right, guys, great to see you, and we will see you soon, okay?
Thank
Thank
you.
you, Judge.